This conference will now be recorded.
I'll take attendance real quick. Just as a preliminary matter, we will have folks joining and leaving the meeting throughout. So just something to be aware of. But to start things off, I'm going to just go down the roll, and if and when I call your name, if you would please turn on your microphone and just say here, both so that we know you're here and as a microphone check, that would be quite helpful. So on that note, I'm just going to start. John Cooney.
Here.
Boris Berstein. Okay. Bradford Brown.
I'm here.
Hillary Brill. I think Hillary may be joining us late. Jonathan Cedarbaum. Also may be joining us late. Kate Crawford.
Yeah.
Bridget Dooling. Okay. Tobias Dorsey.
Here.
Don Elliott.
Here.
Ty Feldblum. Okay. Russell Frisbee. Okay. Robert Gerard. Alexandra Gibbons.
Here.
Thank you. Brian Hancock. Okay. Josh Jackson. Saw Josh just a second ago. Kristen Johnson.
Can you hear me?
We actually are a little fuzzy, but we can hear you. Kristen Johnson. Okay. John Kaminsky.
Here.
You. Michael Livermore is not going to be able to make it today. Jillian Metzger.
Here.
Peter Mulligan.
Here.
Thank you. Patrick Nagel.
Hey, this is David Pang filling in for Patrick.
Appreciate it. Note of that. Melissa Nittram.
Here.
Nina Olson.
Here.
Thank you. Elizabeth Pappas. Sorry, I'm going to butcher some names. Okay. Eloise Pasikoff.
Here.
Ricky Rye will be joining us a bit late. Connor Rasso. Okay. Ricky Revez. No, actually, Ricky's not going to be able to make it. Bertrand Ross.
Here.
Shapiro, Ira. Okay. Ganesh Siddharaman. Okay. Coke Stewart.
I'm here.
Elham Tabasi.
Here.
Stephanie Tatum.
I am here.
Thank you. And Anthony Schultz.
I'm here.
All right. That concludes the roll for now. Again, folks will be coming and going, and that's understood.
Hi, I'm sorry, it's Boris Berstein. I joined a couple of minutes late, in case you called my name.
Thanks, Boris. We did appreciate it. I noted you when you joined. Anyone whose name I did not call, who didn't hear their name, who was a member of the committee. All right. John, I think that does it. I think we're ready to get this meeting underway.
Very good. We'll start with opening remarks from Matt Weiner.
Thank you, John. Thanks, Mark. Do we have our consultants on the in attendance? I see Carrie. What about Dan Ho?
I'm here.
And Mark, did you call the consultant's name and I perhaps missed them?
No, I'm sorry, I did not call the consultants, and that's a good
Okay,
point.
can we just
but
confirm that
our
we have
four
them all
project
on?
consultants here today.
So we have Dan Ho, correct?
I'm here.
And David Angstrom
Yes, I'm here.
and Kathy Sharkey.
Yes, I'm here.
Okay, terrific. And Tino Cuellar is not joining us, I assume, right? Okay. Well, Mark, thank you very much. Thank you for your excellent work on this project, especially under the press of time here. Thank you to our consultants. More on that later. And thank you especially to John for coming out of retirement, so to speak, to chair this committee. John previously chaired for a number of years our committee on administration and management. And I don't think there's anyone better. I don't think we've ever had a better committee chair. And John, I hope, as you'll see soon, is very good at imposing order on an unwieldy subject and project, while at the same time allowing everyone's perspectives to be heard. So thank you, John. The only thing I would like to do before turning this over to John is to just to say a word about the scope of the project. And I'll do that simply by reading the council approved project that appears on our website. It's only several sentences, so just bear with me. This project considers whether the conference should issue a statement on federal agencies' use of artificial intelligence, AI, and if so, what the statement should say. Among other topics, such a statement might address how agencies can best assure due process, promote transparency, and protect against the possibility of bias in their uses of AI. The project draws on the conference's existing work concerning agencies' use of AI, including recent reports titled Government by Algorithm, Artificial Intelligence in Federal Administrative Agencies, and a framework for government's use of machine learning. The former report, which I think everyone on this call is well familiar with, was written by Kathy Sharkey, Dan Ho, David Angstrom, and Tino Cuellar. And the latter report, which arrived this week, it was written by Carrie Colonese. And thanks to all of you. With those very brief introductory remarks, let me turn it over to John Cooney. John?
Thanks, Matt. I'll start with a discussion of the ground rules that will govern the meeting today. ACUS members have full speaking privileges and are able to unmute themselves. To avoid background noise, though, I'd ask that you keep your microphone on mute and add a comment in the chat feature if you want to speak, and I'll recognize you. Then at that point, you can unmute yourself, but then please remute yourself when you're done, because we may have as many as 40 people here, and the odd barking dog could make it difficult for all hands. For members of the public, please use if there are any who've logged on, please use the chat feature to indicate if you'd like to speak, and I'll turn to you at an appropriate point of the meeting after asking the members of the council whether they want to allow or we have time to permit members of the public to speak. For all participants, please use the chat function only to indicate that you'd like to speak, or for committee members to vote when asked to vote. But please do not hold any sidebar discussions on the chat feature or put substantive comments there. We want everybody to have the benefit of your thinking. And then finally, only for members of the committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsel. If we do happen to have a vote, you're the only ones who may participate in the vote, and do not vote unless you're a member of the committee. All right, those are the technical details that we needed to clear up. Looking around the list of names who are shown here, I know that we have a lot of intellectual firepower with us today, and ACUS greatly appreciates your coming together to share your collective thoughts about what we ought to do about agency use of AI. We've got lots of smart people here who will want to be consulted and speak. And as Matt said, we have a lot of topics to discuss in a relatively short period of time. So we'll need to guard against filibustering when there is so much to cover. So I'd ask you to try to keep your comments as short as you could while still getting your principal points across. I personally want to thank the consultants for the reports that they've given us. I've read those, and they're really quite staggering in the amount of thought and work that went into those. The two consultants' reports, I think, will provide a lot of information about the current use of AI by agencies that we can share with other agencies. The question for ASC, as Matt said, is what should we do with this information? The logical thing to do, as he pointed out, is to draft a short statement to accompany the bulk of the material. And I want to emphasize that the statement probably should be very broad and should be short because we're going to be handing people enough information to read, and we just want to give them the high points. It's very important to get the high points in. High points is determined by the collective judgment of the people who will be speaking. And I hope we can develop consensus here. There are really two questions that we'd like to get to the bottom to. First is, what information can we provide the agencies that would be helpful to them in making their decisions about how to explore the use of AI and then how to decide when to use AI? The first stab at some of those issues are on the agenda list. And the second question is, we know there are going to be major legal issues in some uses, or what legal issues do we think that we should make the other agencies aware from the get-go? And as Matt said, some of those critical issues, as recognized when the project was authorized, are set forth at the beginning of the points for possible committee discussion. So, as I said, our goal here is to hit the big points in the statement. And I think also ACUS will be very interested in your sense of what the big points are, to consider whether it would like to generate new studies, future studies in some of the areas that you identify as potentially interesting and important that have not quite been covered yet in the, or at least to the extent you think they should be in the consultant's report. So as I say, the goal for today's meeting is to make as much progress as we can on those two questions and try to see if we can figure out what should be highlighted and see if we can start moving toward consensus. One last point, especially for our high-powered experts, the statement is going to have to do translation in 2 dimensions. It's going to have to translate the technology for those of us who are not technologically savant. And it'll be useful if we could try to start laying out the words that would be used in this discussion to communicate effectively with non-tech experts. And the second one, which will apply to everybody on the call, is we're going to have to translate the legal doctrines here. We're going to have to try to make that as simple as we can for the technology consultants in the agencies who will be looking at this and working with their lawyers to try to find out a solution. So please don't get too technical on those if we can possibly avoid it, and try to use the more colloquial terms that you might feel appropriate using with a smart person who just isn't trained in this area. And with that as by way of intro, we should start with the discussion of possible topics to be included in the statements. And I think we should start with the first one, bias and artificial intelligence decision-making. And I'd ask if there's someone, if you could indicate by the chat feature that you'd like to kick off the discussion on the possibility of bias, which is a topic covered at some length in both the consultants' reports. Daniel Ho, you're first to sign in, and so that you'll be the first to speak. Please proceed.
Sure, thank you. And it's great to see this committee come together around such an important issue. And thanks for ACUS's leadership and for the opening statements. I guess I'll keep it pretty short, but I think that one of the most important emerging issues really over sort of the past 5 to 10 years as AI has blossomed has been the recognition that due to a variety of mechanisms like bias in the training data, sort of selective samples, the use of AI can in fact encode forms of bias. And so I do think it would be important to include that in a kind of statement, ideally really to foster thoughtful adoption of AI to make sure that there is a kind of bias audit conducted when first implementing a particular system. To make that concrete, right? We have Elham Tabasi from NIST on the line. Really important that NIST has done work to understand how facial recognition technology performs across demographic subgroups when an agency like the Customs and Border Patrol sort of considers its adoption. So I would, if the goal here really is to get to what issues should be in and out, I would think that some recognition of the immense amount of work that many have done to articulate how algorithmic decision-making can, in fact, encode forms of bias would be really useful.
Thank you. Don Elliott?
Yes, thank you. I really enjoyed Carrie Cognalisi's report. I enjoyed the other one as well, but Carrie's on this point, I thought did a particularly good job of identifying the fact that human decision-making is imperfect as well, and summarizing many of the biases in human decision-making that are cataloged in emerging literature in psychology, but also in related disciplines in law, like behavioral law and economics. However, there is an argument which was made first by Herbert Simon in his amazing book, Administrative Behavior, in 1947, in which he claimed that part of the purpose of creating administrative bureaucracies was to overcome the weaknesses in particular human decision-making, and that by combining people, you could overcome these cognitive weaknesses. That's also an argument that others like Cass Sunstein have made, pointing to disciplines like benefit cost analysis and the procedural process in agencies as ways of potentially correcting for the human biases. So just pointing out that there are human biases as well, I don't think completely solves the problem. And sort of a related point is, I think we should look to other successful models, and I've got several in mind, but I won't belabor them. But there are other places where other groups have successfully introduced sophisticated techniques. I think particularly of the National Academy of Sciences and some of the fundamental changes in the way that we understand toxicology growing out of the Academy's 2007 report. And what agencies did there that was particularly successful is, rather than doing side-by-side comparisons, which is what I actually had advocated in some articles, instead the agencies simply began using some of these techniques in combination with human decision-making and giving them what value they were worth. So I would just suggest that we look at other successful models in government where scientific paradigms have changed and try to learn from them.
Thank you very much. Toby Dorsey, you're on.
Hi, thank you, John. I just want to speak very briefly from my perspective as a former staff member at the United States Sentencing. The use of AI or different sorts of algorithms, supposedly objective algorithms in criminal justice and in particular in sentencing, has been studied at length by the Commission as well as by scholars and others, and it is extremely problematic and extremely complex. So I'm not saying that this is not something that we should be pursuing, but we should do so extremely carefully. And I would encourage anyone who's interested in this to look at Title 28, Section 994, subsections D and E of the United States Code, those provisions are the directives to the Sentencing Commission on what they can and cannot consider in developing sentencing guidelines. And I think that is a useful framework or starting point for how any use of machine learning or AI might proceed at an agency.
Toby, you said extremely carefully. Could you give us a quick indication of some of the areas that you think bear special attention?
Well, the thing that comes to mind is that, in fact, I think Kerry has in his report, which by the way was extremely good, and I think the discussion about the implicit bias that humans have, I loved all that stuff. I'm familiar with the underlying literature, but the problem in the sentencing context can definitely arise when you have the guidelines, or I'll use the sentencing guidelines as the example. When you have the guidelines considering the use of factors that on their face are not actually discriminatory, but they're sort of proxies for things that are discriminatory. For example, in Pennsylvania, they have, and Professor Coglianese may be familiar with this. In Pennsylvania, they have a sentencing guideline system that doesn't take into account the person's race, but does take into account their zip code. And if their zip code is in an urban area, for example, then they are being charged. They're going to be treated more severely by the sentencing guidelines. Well, the fact is that urban zip codes are proxies for race, or at least that's the argument, and that's the discussion. So we have to be very careful as we move into these areas to make sure that the factors that are being considered are actually appropriately neutral factors given our civil rights and constitutional requirements.
Thank you very much for that example. That's very useful. Nina, I'll skip over you for the moment if I could and go to Deirdre Mulligan and ask that you be the transition to talk on this issue and then speak on due process as well. Deirdre, could you proceed?
Sure. I wanted to raise one concern is that it was odd to me to read a report talking about bias that didn't talk about automation bias. And, these systems are being put in place in socio-technical systems. It's not like we're looking at humans and machines. They're going to be combining. And there's a pretty rich literature on automation bias. And there's a bunch of, work in organizational sociology and other places that actually looks at the introduction of these systems and how they are actually used by humans. And I think if you're going to do something on bias, you need to engage with that literature in a meaningful way. We can't just talk abstractly about the kinds of biases that humans have a propensity to. And I think it's also important to think about the biases that we need to think about at the kind of legislative process, the ones that we might need to think about at the rulemaking, and then the ones that actually are kind of likely to be expressed when individual agency staff are making a decision, and that the biases that are set out don't necessarily all operate in the same way in those different places. So I think that it's pretty important to be a little bit more specific on that. Thank you.
Thank you very much.
And yes, I am talking about the latest report.
Okay, thank you. Nina, if you could go next, and while Nina is speaking, if there are others who want to line up to be heard on the procedural due process point, please put that in the chat function. Nina, please proceed.
Thank you. So I thought I would share some experiences that I had when I was National Taxpayer Advocate at the IRS, and then go to Deirdre's comments. The IRS created something called the Reasonable Cause Assister, which was to help their employees decide whether a penalty should apply, or did the taxpayer have reasonable cause for taking a position that was actually erroneous according to the IRS. And those penalties are very, very steep. And that Reasonable Cause Assister was a decision tree that you basically, answer certain questions and the machine went chunk, chunk, chunk and said yes or no, get the penalty. They also, rightfully so, and this goes to the human-machine interaction, programmed in a safe harbor where you could override if you felt as the employee that the machine hadn't weighed the factors properly, or there was a factor that didn't come up that you knew about that the taxpayer had provided. The IRS did a test and, you know, set up fact scenarios for its employees where the end result should have resulted in an override. The employee should have said, you know, the machine is telling me apply the penalty, but this doesn't sit right. And in 0% of the time of those tests did the employees do an override. And the reason was because they came to depend, one, so much on the machine, but also the IRS, because the machine, you know, algorithm existed, they ceased training their employees on the legal factors of what constituted reasonable cause. So they had the knowledge to say, oh, this is the wrong result in this circumstance. And so I bring that up as, you know, an example where you really have to think about how the machine automation and algorithms are actually applied and utilized by the employees. With that same algorithm, we found, and I issued as a most serious problem for taxpayers several years ago that I'll share with everyone on the call later, I identified that the IRS was doing policy through programming. You know, when you have instructions to staff, first of all, they are subject to eFOIA unless they meet some of the exceptions. And so the rest of the world can see the instructions that the agencies are giving to their employees, and the IRS Internal Revenue Manual is public, and we all as practitioners can see them. But when it's put into a machine or an algorithm, you don't know what instructions are being built into that machine. And we found several examples as we went through scenarios that the algorithm actually had policy in there that had not been approved by anyone, had not gone through the clearance or circulation route that normal instructions for staff do. And the last point I want to make that sort of segues into procedural due process is the issue of false positive rates. That when you have, and again, with the IRS, I'll just use the IRS as an example because I've spent years of my life fussing at them, is that when you have an algorithm that is identifying, for example, with the IRS, a questionable refund request, the machine spits out, based on all sorts of algorithms and filters and business rules, this return is questionable and therefore we're going to freeze the refund. And that can be frozen for months, if not years, and getting an IRS employee to override the machine becomes very, very difficult. Again, it becomes that the machine has said this, and this is an independent and objective thing. The IRS actually has had in 2019, in one category of questionable refund claims, an 81% false positive rate, meaning 81% of the returns that were frozen turned out to be legitimate returns, and people had to wait months, if not a year, to get their refund. And so I think in the due process arena comes in, what is the procedure if an algorithm identifies you as X or makes some kind of recommendation? What is your procedure to address that and get, a relief of that label, if you will? And as well, that there has to be in a concurrent plan for minimizing false positive rates in the context of utilizing machine learning and artificial intelligence. Thanks.
Thank you. I don't have any requests in the chat room to speak at this point. I don't know if this is caused by a technology problem or not, but I would ask, and while waiting for others to come online, if one of the consultants would like to take an opening stab at this point and discuss what were the things about procedural due process that really struck you in the course of preparing the report.
I'm happy to weigh in if you'd like, John.
Thank you, Kerry. Go ahead.
Sure. Let me start by, first of all, thanking you, John, for chairing this big group, and Mark for organizing, and ACUS for sponsoring. I would like to just maybe as a bridge from the discussion of bias into due process, just highlight what I hope will be an overarching theme that we can all think about when agencies are thinking about using AI and concerned about issues like bias. I think the relevant question is not necessarily whether the AI will be perfect. We do know that machine learning, as much as it can make improvements over human decision making or human forecasting in many instances, it's not perfect. It will have mistakes too. And I think that the relevant question to frame everything is the agency doing something better than it is at present? And it may be that there are some imperfections. It may be, by the way, that with respect to bias, the algorithm itself may be easier to adjust and recalibrate to eliminate bias than getting it out of human beings. So all of that is just a general comment. With respect to procedural due process, in one respect, you could look at this issue through the lens of Matthews v. Eldridge, which is the prevailing test for whether process is due, a particular type of process. And I think if you look at the three Matthews v. Eldridge factors, machine learning in principle should fare quite well, assuming that indeed it can make some improvements over the accuracy of human decision making. Of the three elements, the one about the individual's own interest is sort of exogenous. That will be what it is, whether you have a human decision making process or you have a machine learning process. But the other two factors are, well, how much will a particular process or procedural step or technique fare in terms of improving the accuracy of government decision making? And again, in principle, that's the advantage of machine learning. So it should fare well there, at least when it's well designed. And then the third factor is, government interest, and usually that's thought of as the government costs. And I think it's worth putting out on the table that there's real potential advantages here in many instances. And as the Stanford and NYU report shows, many agencies are pursuing machine learning, presumably to reap some of these advantages from the government's interest in lowering administrative costs. So I think from procedural due process, at least under the Matthews v. Eldridge framework, machine learning is something that should fare well. And I think to build on Nina's point, I think that the key is really to do that analysis and be able to document that in terms of accuracy, it's making an improvement over the existing processes.
Thank you, Kerry. I still don't have anybody up on the board. If anyone wishes to be heard, just send a chat immediately and you'll be next to speak. Yeah, Catherine, yes, Catherine.
Yeah, thanks, John. And again, really happy to be part of this group. Just one quick thing, listening to the conversation struck me. I don't think in either of the reports we captured something that, we captured some of the theory, but not practical examples of the type that Nina was raising. It might be extremely fruitful, especially with experienced folks on this call, to actually have examples of, for example, pilots that were run and specific false positive rates, et cetera. I think that each of the reports talks, as again was done in a very deft, delicate way, not as a hard critique, but each of the reports talked about this issue. But to have kind of practical, empirical, even if it's anecdotal from this group, I think that might help to frame a discussion that goes beyond either of the two reports, doesn't just sort of leave things where it is.
Thank you. Does anyone on the committee have a point that they'd like to make about that? And then I'll come back to Nina. Some practical examples in your experience. Well, not seeing anything come up. Nina, back to you.
Yeah, I didn't want to say that I was opposed to using these kinds of things. I think that, my examples, and I can certainly send them to you all, is that you really have to think through them, and you have to have processes for people to challenge whatever the determination is that is, or the result. And those processes have to be identified ahead of time, and your employees have to understand the role of the machine learning, that it's not the final answer. There are these due process concerns in terms of right to challenge the position. And I think if you do that, then you have the protections that you need. And that also creates the continuous loop. Then the machine learning learns, it becomes better. And to your point, you can then program that in to the system that, oh, we've observed this, now we have to program that aspect in.
Interesting point. Thank you. Daniel Ho, you're up next.
Sure. Just to kind of connect a couple of these threads, I think going back to what I think Toby had mentioned, the leading example sort of bias comes from a 2016 piece by Julia Anglin and others at ProPublica that basically showed that the false positive rate for minority defendants was about twice the rate as that of non-minority defendants, given a high-risk classification. And really, that was one of the important leading points, really showing the really great potential for algorithms to perpetuate bias beyond what one might expect through purely human decision making. So I do think that the strand of procedural due process that we're talking about right now in terms of accuracy and bias can be very directly related. I guess the other point that I wanted to just say something about on the procedural due process side, I think the part that I think is a real challenge within the administrative state is that our current procedural due process scheme really prizes individual error correction. And the kinds of errors that Nina Olson is pointing out are systemic errors in the way that a machine learning system, for instance, has been built out to generate something like an 81% false positive rate. And ACUS, of course, has a long history of trying to think through how we use administrative law principles to get at sources of systemic error like this. And going back at least to Jerry Mashaw's work, we know that individual appeals have not been particularly successful. So what I think would be very useful to think about is really the point that Nina makes, which is how does one ensure that there is enough quality assurance when a machine learning system is built out to have the kinds of management processes so that you don't rely on a kind of ex post appeals mechanism that is really imperfect given the capacity of appeals courts to do the requisite kind of fact finding depending on the agency. So I think that is a really critical thing to ensure that all of this, these forms of audits and management controls are put in right as the system is being adopted.
Thank you very much. Don Elliott, I apologize, I skipped over you last time. Please go ahead, and then Bertrand Ross, I'll turn to you next.
No problem. I think Daniel and I were both at 138, so it was a tie. I just wanted to say that I agree very much with what Carrie Cognalisi said a while ago, that the relevant questions really are not, are these techniques perfect? Are they subject to bias? But the comparative technique or the comparison to existing approaches, there have been a number of them. Going to the question of practical examples. There are a number of them in the environmental area that are not exactly machine learning or artificial intelligence, but I think are analogous enough that we can learn some things from them. And I think one of the things that experience with air modeling or using qualitative structure activity relationships to predict potential toxicity. I think a lot of the experience at EPA has gone to the question of incorporating the AI techniques into an existing administrative process, but leaving the door open for people to use the procedural due process approaches to raise issues, such as the issues that others have talked about with the implicit bias of using, say, zip codes, which have a correlate with race. The difficulty of trying to make a comparison at the front end, and this is that you can't then cut off anybody and say they can't speak or raise other issues that weren't considered at the front end. This is also, I think, one of the lessons. There's an excellent report by the National Academy of Sciences called Models in Regulatory Decision Making for the Environment. And one of the points it stresses is what it calls model evaluation, or as opposed to model validation, but they call it model evaluation because they make the point that it should be a continuing process as we get more experience and as we learn. So I would just caution that, yes, while we ought to make a comparison at the front end before we introduce AI techniques and compare them to, the alternatives, I think the experience of other agencies which has been successful suggests that it's very important not only to correct the product, but also for acceptance to leave open the possibility that people can use the existing mechanisms of procedural due process in the administrative state to raise questions about the AI, and it's not ever a closed subject. I think that obviously has to do with the nature of science, that it is continually progressing. So I would just urge that we learn some of those lessons and leave open the possibility for people to raise questions about the AI techniques.
Thank you. I see we have 4 more speakers lined up on this important issue. And I love the examples that we're getting here. So I'll go through the list in order. Bertrand, you're next.
Great, thank you. And I just want to kind of make a point returning us to the bias point, but not to get us too far away from it. I think it's important in any statement that ACUS might issue in combination with the reports that we acknowledge or emphasize something that's implicit within the NYU Stanford report about the differential propensity and costs of bias in different agency settings. And I understand the importance of accounting for or describing the administrative agency apparatus as a whole to provide some guidance to a broader set of constituents. But I think it's important to sort of acknowledge, and again, that bias will have different propensity and costs in a context such as the Food and Drug Administration's post-market surveillance of drug side effects versus the Social Security Administration's administration of benefits versus the Office of Criminal Justice Program or sentencing, the Sentencing Commission's enforcement of criminal or civil laws. And so I think that we should sort of acknowledge that, and there might be sort of more room in certain settings for making adjustments and experimenting with different AI processes to account for and reduce biases. But the cost of biases in certain settings could be high in terms of the public legitimacy of the institution and the agency and its functions, to the extent that they are more directly impacting human terms of benefits, property, lives, and whatnot. And so an acknowledgement of that, I think, is important to include in any sort of statement in the report.
Thank you very much. Alexandra, you're next.
I wanted to add that CDT actually published a report yesterday that does a deep dive on the due process arguments in a number of cases where beneficiaries under the Medicaid waiver program have sued over the reduction of their benefits. These are cases that have been litigated, gone to a judge, and what you can learn from them is a really interesting example of judges grappling with these hard questions of what notice, explanation, and ascertainable standards actually look like. But the other piece that they're butting up against, and that I think is really important to mention in anything that comes out of ACUS in terms of recommendations, is the proprietary claims made by vendors that are creating the tools. These are acknowledged in the report, but I think it's worth pausing to underscore how important this is, both for addressing due process concerns and for agency capacity issues as they're deciding whether or not to use these tools and how to evaluate them. I think the most important takeaway is that need to be empowered at the contracting process to be able to know and exercise influence over those proprietary.
Thank you. That's an interesting point about giving the agencies a heads up as to the problems that they might have in litigation somewhere down the line, and to think about that at the beginning of the process. David Engstrom.
Hi, I should start by just echoing what some of the other consultants have already said. That would include Carrie and Dan and Kathy, and just thank ACUS for the opportunity to have written these reports, and then for the further opportunity to take part in this really important conversation. I wanted to make a brief point about what I see as a scoping challenge for this committee, and making any kind of a statement that touches on due process. And I think a nice way into that scoping challenge is the really excellent turn in Kerry's report, where he talks about different lenses that an agency could bring to bear when thinking about whether to deploy AI. And one of the lenses, of course, is the Matthews balancing test, and an agency could think through that in anticipation of an eventual judicial review of its tool. And that, as Kerry noted in the report, would be very much an accuracy-focused inquiry. That's the way the Matthews balancing test has moved in recent decades. You could imagine a slightly wider lens, which is a more kind of cost-focused cost-benefit analysis. And as Kerry noted, as we all know, that means reducing all costs and benefits to some sort of monetary equivalent and then tallying them up. But Kerry also noted a further lens that an agency could use, which is a still wider multi-factor analysis. And an agency might need to think, therefore, about a bunch of hard as well as soft considerations. So non-instrumental values, dignity, legitimacy, things that aren't actually present in the conventional doctrinal structure, say the Matthews balancing test that governs procedural due process. And so I think something that the committee is going to struggle with, and I think this is going to echo across other parts of the statement as well, is how closely does the committee want to hew to the conventional doctrinal structures and help agencies think about how to structure themselves in anticipation of an eventual court judgment? And how much does the committee want to help agencies think about how they might structure themselves internally to provide, say, internal due process? And let me just give you an example. This is something we touched on in our ACUS report, and it's a really important one. So the SEC has developed a series of very interesting enforcement-related tools. And what happens is a central group of data scientists within the agency develop a set of machine outputs and then send those outputs to line level prosecutors, who then take them into account in making their line level prosecution decisions. And as we engaged with the agency, what we learned was that the line level prosecutors are quite skeptical of that machine output. And when those outputs are simply handed off to them, they're not particularly impressed by the notion that this particular potential regulatory target threw a flag. They want to know why. They even want to know maybe which part of, say, a narrative disclosure that was provided by an investment broker threw that flag. And so there are all of these questions then around internal due process and things that agencies can do in terms of, say, how they structure that handoff of an algorithmic output to the actual decision makers within the agency that very much have due process implications, but that might not sound in due process as it would be analyzed by a court applying, say, the Matthews balancing test. And so again, I think that is going to be a struggle for this committee. How much do you want to hew to the doctrine, and how much do you want to think more broadly about agency structurings that help cash out due process values, but that aren't necessarily cognizable under the doctrinal tests?
Thank you very much. That's a fascinating point. John Kamensky, you're next.
Thank you very much, John. I wanted to just bring up some research that's being done at the Princeton University's Project on Computational Law. There's a team there that's developing a framework for using computer models to see if artificial intelligence can detect implicit bias and inform decisions, specifically by prosecutors and district attorney offices. And they're using data from real district attorney offices around the country to be able to inform what they're doing. And what they focused on specifically is their efforts on potential bias and whether initial criminal charges should be reduced based on the facts of the case. And they constructed some models that helped inform those decisions. And they did some of these models that were just like, this is what the data show. And then they did it as if It was race neutral by doing things like stripping out zip codes and other potential influencing factors. And then they did it as if they were white only cases, and then showed the comparisons to the prosecuting attorneys to show them where there might be bias implicitly in some of the decisions they're making. And so it wasn't that the AI was being used to make the decision. AI was being used to train the district attorneys to be able to better understand where they may have implicit bias. The authors of the research that's going on have described ways of what are the key elements for designing an AI decision model, as well as designing the AI framework. So there is some thinking that reflects a lot of what we saw from Carrie's report and Daniel Ho's report that builds on this in a concrete, specific, practical case that's based on hundreds of thousands of cases.
Thank you, John. That's fascinating. It's very interesting to the extent to which this group has its finger on the pulse of what's going on, not only in the research community, but in the experiments that are being conducted. Coke Stewart, you have a question for the group. Do you want to present it?
Sure, I'd be happy to. I work at the USPTO on AI policy issues, but one question I had is we're looking to use more tools in our patent and trademark examination process. Is, outside FOIA or other mechanisms, what access will or should the public have to the rules that are going to govern the AI system?
Would somebody like to take a crack at answering that? If you do, why don't you just raise your hand on the screen and I'll call on you. So I think there was some discussions of questions along these lines when we got to the procurement aspect of what an agency might want to do. Carrie, I saw that you just popped in. Could you proceed?
Sure. Just on this point, I think this relates to, and maybe will come up when we get to the point on the agenda about transparency. But I mean, one of the challenges with machine learning is it's what's often called a black box algorithm. And so the underlying rules are hard to always intuit or at least explain easily. So that is one of the challenges that is common with the AI tools. I don't know that it's insurmountable, though. I mean, I think we can explain what the algorithm is designed to optimize for. We can talk about the data. And there's a lot of advances being made today by the technologists and the data scientists on advancing explainability. It will just not, though, be explainable in a causal sense often, or necessarily in the kind of rule-like fashion that lawyers are used to understanding these things.
Thanks very much, Bridget Doolin. Oh, I'm sorry. I may have gone precipitously there. Let me come back, Bridget, to Coke and ask if that answers your question, or if there's something else that you'd like to discuss on this point.
No, I think that's helpful, and I'm sure it will come up again in transparency. I mean, for the benefit of the group, in reviewing patent applications, we had some systems in place to flag applications. We called it a sensitive application warning system. And we ended up getting in protracted litigation about that system because some stakeholders viewed that we didn't share enough information about it, and we didn't include enough detailed information about the system and the particular decision making that we were engaged in. So I just throw that out for further thought as we continue these discussions.
Thank you. Bridget will be next, but my computer has just flipped on something that may cut me off and I may have to log back in. So Bridget, if you could proceed, and I may disappear here for a couple of minutes and then I'll be back.
Okay, we'll miss you, John. All right, hi, thanks everyone. It's been a great discussion so far. Professor Engstrom, I just wanted to follow up on something that you raised to make sure I understand. You suggested that there's a question for this committee to think about how much we want to aim to hew to, current due process doctrine, or, set our sights on something about more internal, some sort of internal version of a due process control or system. First, did I get that right? And then second, if so, do you understand those to be mutually exclusive or something, or just like two separate work streams that we should consider taking on simultaneously?
I don't think they're necessarily mutually exclusive. If I'm understanding what you would mean by that. I mean, I think it's possible that lots of questions of how agencies internally structure themselves when using these tools, and how they structure that handoff of the outputs within the agency, or the kinds of provisions they have built in for midpoint evaluations of a tool. Is this tool still serving the purposes it was designed to serve? Even endpoint questions about, is it time to decommission this tool because it's run its course, it's no longer useful, or it's been, whatever analytic leverage it provided has been superseded. All of those things I think could be cognizable under Matthews, I suppose. I could imagine a court, and especially a judge, a trial judge with enough understanding of the technology, could go into those things. But I do think that something like the Matthews balancing thin filter, and we all know that it's really residual review of agency action in most contexts. And so in that sense, I think it really could be thought of as two tracks, and there are going to be lots of considerations that agencies take into account and implement when they structure themselves to utilize these tools that are never going to be reviewed in court. When I said that that's going to echo in other contexts, I think that's going to show up in the enforcement context. I was planning to talk about that around transparency. We've hived off most enforcement decision making from judicial review with a combination of Heckler and Standard Oil and standing, the doctrine around what's a legislative rule and therefore needs to be pushed through the notice and comment process. And so that's creating these gray zones where there actually isn't much outside, external, legal, court-centered accountability of agency action. And so I think, that's another place then where internal agency structure is going to matter hugely. And I think there's a real opportunity for this committee then, rather than telling courts how to decide, telling agencies in areas where there isn't likely to be lots of judicially imposed accountability, helping agencies to understand how they can structure themselves to, again, cash out due process values. Is that helpful?
I'd like to, we've been having a very interesting discussion here, and I'd like to move on to the next people here. Bradford Brown. Then, I'm sorry, Kate Crawford.
Hi, everybody. And I'd just like to give my thanks to ACUS for this really important convening, and to the extraordinary group that we have here to consider these issues. I'd just like to connect 2 points, one that was made by Alexandra earlier on the proprietary nature of these systems, and also Dan Ho's point on the importance of auditing mechanisms. I think it's important here to realize that auditing is going to be essential for revealing structural flaws in machine learning systems. And I think it's going to be continuously clear that we need to do that as part of the procurement process. We've certainly seen what happens when we don't have a careful auditing system at work. And here, of course, I'm thinking of things like the UK government's Office of Qualifications and Examinations regulation system that they used for grading standardization, which, of course, incorrectly downgraded 39% of A-level students across England, and specifically had quite disproportionate effects on students at underfunded schools. Now, this was a case where a system was not audited, it hadn't been tested in advance, and certainly things can be done. In the algorithmic impact assessment report that we produced in 2018, we looked at many ways that you can build in to sort of a public review system, the ability to test and audit machine learning systems. But I want to raise 3 concerns that I have that I think connect to both Alexandra and Dan's points. The first is this problem of trade secrecy and proprietary algorithms. This makes it extremely difficult to audit these systems and to understand where these structural flaws will appear, and they almost always do appear, and I think it's important to recognize that. Secondly, I think is this problem of difficulty and expertise in auditing. This is actually quite a new area. There simply aren't that many people who are very skilled at auditing algorithmic and machine learning systems. This is something that I've spoken to sort of multiple auditors about, but also people who've attempted to proceed with any type of legal action against these systems. We've documented some of these in the Litigating Algorithms report, but this is quite a serious problem. And then finally, I think this idea that some of these problems are just extremely hard to find, even if you have a very skilled auditor. This is particularly true in deep learning systems, but really it's across the board. I liked Chris's note of the Amazon resume scanning system that was found to have very serious problems. I would note that that took the company 3 years, and that's with all of Amazon's resources and engineers, to actually spot that it had a systemic problem in terms of gender bias. So this is to say that I think as a committee, we need to be careful in assuming that we can make these systems transparent or accountable within a procedural due process framework. Thank you.
Thank you. It's a great asset to ACUS to have people like you here who are able to look around the corners and anticipate the problems that have been seen in small areas now, but are obviously going to become more prominent as the AI development occurs. And finally, Jillian Metzger. Jillian, I'd like you to speak, and then I'll turn to the next topic on delegation and accountability.
Okay, great, thanks. So I'll begin just by echoing the praise for the reports, which I found really great and such a range of different information and approaches and issues flagged. The thing I was struck by as I was listening was the contrast between the discussion of the SEC and the IRS. And I think it reinforces the importance of the question of understanding that somebody said this is all contextual, and it's contextual not just in terms of the questions that are being done and whether it's enforcement and whether or not it's regulation or so forth, but it's also contextual in terms of agency culture and norms and the extent to which there's a culture that really supports taking an assessment, critiquing, and also constructive approach going forward. And part of the internal structures that David was talking about, I think, would have to be about recognizing you have to be constructing that culture and that approach at the same time as you're building the structures. If you simply put in the structures and hope that they will work in a culture in which criticism and assessment are not actually seen as something that the employees or those who are engaged in this are supposed to be doing, then I don't think that's going to provide very much very much support in terms of addressing these concerns. The other thing I would just say, just a couple of points, one on the auditing issue, and then the question of internal. Both of those strike me as needing not just to be internal, but also to have external participation, if for nothing else than for the legitimacy concerns. Because auditing is, of course, not entirely neutral. It depends a lot on what you're auditing for and what your values and criteria are. And so making sure that you have external input as well as internal input into that, I think, would matter if those structures are going to be serving a legitimizing function. And that's also true about just basic implementation. And the final point that I just want to mention, because I haven't heard it mentioned yet, is just resource scarcity. You know, doing this well is going to take resources, and it will be trade-offs. There may be resources saved in some ways, but I think the idea that you can do this well and end up saving dramatically on resources is one that it can be dangerous, because I think it ends up meaning that you do the artificial intelligence without doing all the supports that are necessary to make it work well. And I just think that's something that really has to be flagged in any statement.
Very good. That's an interesting point. As an old OMB person, I'm making a note myself on that. Now let's move to delegation and accountability. I don't have anybody up on the chat list yet volunteering to open this discussion. I'll give that a few seconds, and if not, I'll ask one of the consultants that covered this issue to kick off the discussion.
John, can I just say, I think Deirdre Mulligan was having trouble getting into the queue, and she may have wanted to speak on the earlier issues still. So I just put her in there. Is it possible to still get her in there?
Certainly. Deirdre, can you hear me? And if so, go ahead.
Yeah, I'm sorry. I can't seem to get the chat function to allow me to reply all. It is only allowing me to reply to specific people. So sorry about that. I just wanted to connect the due process concerns and the bias concerns and note that, when we think about the introduction of the systems, and again, this goes to the potential, I think, automation bias issues, it's a really important question about when to audit them. And there's some really interesting work by Bo Cowgill that was looking at the ways in which the way risk is portrayed back to judges over time systemically produced bias results, right? That it was looking at kind of where people fell in relationship to high or low risk, or medium and high risk, and how judges responded to that input with respect to different other, and so this question of like when to look for bias, I think it's really important to know in these systems, we don't just want to look at them at inception, but you're going to want to look at the system's effect over time. And I think just to go back to Kate's point that it's going to be really difficult for those to come up in kind of an individual due process. It requires a more systemic approach to thinking about bias and to thinking about how we police it.
Very good. I need to apologize to Kate Crawford for having demonstrated my lack of technical ability on these virtual comments. So if you would like to go ahead, please proceed.
Oh, no, John, I'm fine. I've already spoken, so that's fine.
Okay, good. I'm really demonstrating my lack of ability here. Let's see. I think Dan Ho, then, you have a comment to Bridget about Jerry Mashaw. Would you like to go ahead?
Oh, no, that was just privately. That was sort of just following up on her. I think.
All right, I see. I'm getting a larger group of emails than others did. So that means, let's see, it's Toby Dorsey, I think, is up next.
Hi, thank you. I'll just be real quick. I thought that the material on delegation and accountability had a gap in it, which I think is a significant gap. I think that when we're discussing the delegation from Congress to the agency, that's one framework. But when we're discussing sort of the delegation from agency decision makers to contractors or contractor built algorithms, then I think we need to look at the federal acquisition regulation, and we need to figure out whether we're performing an inherently government function and potentially illegally outsourcing that in violation of the FAR. So I would encourage some consideration to be given to FAR Part 7.503 and the list of inherently government functions there and that cannot be outsourced by a federal agency.
Thank you. I agree from my days at OMB that we're going to have to deal with the FAR process and OFPP before this is over. Thank you. Let's see. Now I think I can say that I'm back on solid ground with Josh Jackson wanting to speak on accountability.
Yeah, so thank you. I have a few comments on this because I think the initial report was a little inaccurate in terms of my own personal, based on a little experience with the algorithms, is that I don't see it as a black box and that you can't extract and hold people accountable for the variables that are related to bias or due process. And I say that it's just not as readily available. So it might not be as readily available to find some of these quote unexplainable. I think they're explainable. It just takes a little time to find them. One example would be in terms of it's going to take resources, would be I could make the argument about FOIA, right? And how we've noticed that it's taking a long time to get these FOIA requests answered. But I think this is an example where we can use automation to sort of sift through and make judgments based on the law and how these are requests, how the policies are written to get those FOIA requests or show the accountability of each of the agencies and how they're adhering to the policies. So that's my one example there.
Thank you. David Engstrom.
Just a very brief point, which is that when we think about a delegation, there is for sure the question about private delegations of public power, and that raises this question of tools sourced through the procurement process. I agree that that's very important and something that I assume we'll talk about when we talk about sourcing and building internal capacity. Another delegation framing that's worth thinking about and that might make its way into an ultimate statement by this committee is subdelegation. So the Morgan cases, and I seem to recall that in some of those seminal papers on algorithmic decision-making in public sector, I think it was maybe in your paper, Carrie, but maybe also Tino talked about it in a paper that he wrote, I think shortly thereafter, like that you can imagine, you can conceptualize the use of an algorithmic decision-making tool as a subdelegation. And so I guess, Carrie, maybe you're more recently through that doctrine, and I don't think it made it into your recent report, but I guess I'd be curious as to why and whether it might be worth considering, it might be worth it for the committee to consider including it.
Carrie, would you like to respond?
Sure, there is a lot, as lengthy as the report is, and I apologize for the length and the delay in getting it to everybody, but there are plenty of things that are left out, and you're right, David, that the subdelegation is certainly something that is not in there, and you know, I think there's probably a lot of my little babies, if you will, that I've left out of of this report, at least on the legal issues. I think that the question of subdelegation is really very much also important to be considering here. It really is related ultimately, I think, to Toby's point as well about the procurement and what is it that is really legitimate for humans. Do people have some kind of right to have a human actually review or make a decision for them, or is it appropriate to, in some cases, allow a machine to make those kind of determinations? So it's a real central question. And I appreciate you pointing out that really should be in the report. Thank you.
Thanks very much, Carrie. Would anybody else like to be heard on the delegation and accountability issue? If not, we'll make the switch to the transparency issue, which has already attracted some attention, I think. And since nobody else has come up on the chat screen, I think I'll use the usual shortcut I've been using here and saying, while we're waiting for others to line up on transparency, if any of the consultants who discussed this issue would like to lead off this discussion.
Yeah, I'd like to follow up a little bit on the point by Josh Jackson, because I do think that kind of the explainability and model complexity stuff, it really depends on the range of models that are being implemented by the agency. The kind of standard way within machine learning that we think about this is as a kind of accuracy explainability trade-off. There are some very complicated models that actually do pose real challenges to our ability to explain how the model reached a particular decision. So I'm thinking here of computer vision models that are very complicated, where sure, we can come up with something like a class, what machine learners will call a class activation map, but the truth of it is that all of the recent results in adversarial learning show us that you can add random Gaussian noise and the computer vision model can be fooled into thinking that a chair is a bear. And so when it gets to that state of kind of AI, I think the explainability stuff is much more profound. And a place where we would like to get to is for government agencies to be able to actually make intelligent choices that ride that accuracy sort of explainability trade-off, which may mean in some instances that you don't go with a very complex model and you go with a more explainable model that would meet the SEC line level prosecutor's question that David Engstrom had posed to tell me what is really leading for this case to be classified as high risk.
Thank you. Would anybody else like to be heard on transparency? This sounds to me, a novice like me, as if it's going to be a very complicated question. I don't know how far down the line it is before one reaches that, or in what context you're likely to be called upon to try to explain this. Would anybody like to go further into accountability?
Sure, I could say a brief word about it. It maybe is just offering a possible framing for corralling what I think is a very complicated, disparate set of issues. So I know that Kerry in his report talked about the difference between fishbowl and reason-giving transparency, and I think that's a really nice framing and a useful thing for this committee to think about. Another possible framing would be this distinction between thick and thin transparency, or thick and thin opacity, maybe the flip of transparency. And when we think of thin opacity or thick transparency challenges, we think about technical opacity. We think about what Dan just noted, where some of the more advanced machine learning systems, especially neural networks, aren't explainable or aren't understandable necessarily even by the engineers who have coded them. And so that's the thick transparency, but there are all sorts of thin transparency. Well, let's stay on thick transparency for a moment. I do think that explainable AI is already making progress on that concern. I think it's also important to note that the transparency demands that we might want to place on a tool will vary tremendously by context. This is something that Gillian Metzger, I think that's a point that she made moments ago, very well. We might demand more in the way of transparency from a tool that's used in the adjudication context than we might in the enforcement context. Why is that? In the adjudication context, we might believe that someone who's about to be denied public benefits as a result of an algorithmic decision-making tool is entitled to something like a full explanation of the provenance of that decision. They need to be able to understand exactly why that decision was made and perhaps even what they could have done differently to generate a different decision. That requires a pretty significant amount of decision level information about how the system reached the decision that it did. In the enforcement context, though, we might not like that level of transparency, in particular because of gaming and adversarialism concerns. If you make known all of the details of a particular tool in the enforcement context, then you're just arming enforcement targets with the ability to duck the tool or duck the decisions made by the tool. And so there we might not want full transparency into the provenance of a particular decision. Rather, what we would probably want would be some system level explanations of how the tool is structured, maybe what sorts of data features are included in it, but maybe not. That could actually reveal information that promotes gaming. And so I think the key point on thick transparency is that it's going to vary tremendously by context. And so I think that makes it very tricky to make a very general statement, which is, what I understand this committee may be heading towards. There needs to be at least some concision in what you say. And it's going to be hard to say anything especially useful about transparency, given that it varies so much by context. Now, switching to thin transparency, when we think about AI systems used in the private sector, we worry a bunch about the trade secrets evidentiary privilege. That's a thin form of transparency. That's a form of transparency that I think can be litigated and is probably not going to pose insuperable problems going forward, but we shall see. Now, in the agency context, it's probably that those sorts of concerns are more likely to come up under the deliberative process privilege. And so that might be worth some thinking by this committee and possible even inclusion in a report. And it obviously poses a very different set of questions, more legal than the kind of technical thick transparency the situation does. So that's all I'll say about that. I hope that's helpful.
Thank you. I see one microphone is on. At BB, would you like to speak on this issue, or should we move on?
I wanted to speak also. This is Don.
Oh, Don, go right ahead.
Yeah, just 2 points. I think relatively easy ones, low-hanging fruit. I think the first is whatever kind of validation or reasons to believe that an AI system is accurate or effective, at least in general terms, I think should be made available for those who are subjected to it. There is a lot of evidence in civil procedure as well as administrative law that one of the features of reason giving is that it makes the decision more legitimate to the users. And I think of the DC system for responding to parking tickets. If you get a parking ticket and you appeal it, you get what is obviously a computer-generated letter back denying your request. But you're not told anything about what's inside the black box or why you should consider it a legitimate response to your question. So I think in whatever we do, I think we should address the issue. And I agree with some of the concerns about gaming, although I'm not perhaps as worried about that as some others are. But I think that people should be told something about why the agency thinks that this mechanism is reliable. And I would also just note sort of the narrow legal point in that area with regard to gaming. My impression is that the various quantitative systems that agencies have used for deciding on audits or inspections in the OSHA context or the IRS context, most of those have been ordered to be produced by the courts. At least that's my impression. So whether or not I'm right about what the law is in that area, we should at least consider whether or not agencies currently have a legal right to withhold such information simply because others may be able to use it for so-called gaming. I agree it's a problem, but there's also some law on this.
Thank you. I have no further requests to speak on the transparency issue, so unless I hear from someone to the contrary, I propose that we move on to the data collection, standardization, and security now.
John, could I say one thing just before we leave transparency? I think Matt articulated at the outset that part of the committee's function is not only to craft this statement, but perhaps to identify future areas for conference projects. And I think transparency, for many of the reasons that Don and others have said, I think transparency is one that could be quite fruitful for further projects specifically focused on in this area.
Thank you for the suggestion. I'm sure it's been duly noted. We've seen nothing further on transparency come across the system. Data collection, standardization, and security. And while waiting for other members of the committee to raise a hand, I'd like to see if the consultants would like to speak about something in this area that caught their attention.
I'm happy to just say a few words. I mean, I think one thing is I can say the obvious is that you need data to use these tools, and you often will need large quantities of data. So that's a sort of a precondition for successful deployment of these tools, and agencies need to think about whether they have the appropriate data sets, whether they are in a form that's usable, whether there are ways, and they'll need to there are ways of dealing with these issues about where you have multiple data sets and you try to link them together. So those are just sort of practical aspects that are preconditions. But then, as the topic suggests, there's also questions about the privacy of the data, cybersecurity issues. These are not, in my view, particularly novel or or distinctive to machine learning per se. I mean, the agencies have been maintaining large data sets for lots of purposes for many years, and conducting statistical analysis that raises similar concerns about privacy protection and cybersecurity. Perhaps the only, in my view, distinctive possibility on the privacy grounds is that sometimes with machine learning, it's possible to reverse engineer and discover, make some very accurate inferences about some private information. Maybe there could be value in having something in the statement to caution agencies about engaging in that kind of use of machine learning. But I think the problems are fairly well developed. There's a lot of privacy law, and now cybersecurity standards and methodologies and protections that are in place across the federal government. And those obviously, worth noting, will be important and applicable in this context as well.
Very good.
If I can chime in here, so data is obviously sort of central, and having a good data infrastructure is just the backbone of any kind of machine learning system. People often, sort of use the phrase "data is the new oil." One of the things that was sort of surprising when we went through agency use cases of AI is actually how that there was a fairly high rate at which forms of AI or natural language processing were used really to overcome first order data collection challenges that agencies were facing. So here I'm thinking about, for instance, the Social Security Administration still has forms where the prior employment is a sort of hand-entered field. It's not standardized in any way. And so what you have at the back end is agencies using natural language processing, basically take free-form text fields and get them into structured data. That's a fine use of natural language processing, but it also suggests that if you could figure out if you could solve the first order problem of actually collecting better data to begin with, you're going to be in a much better position to do learning on top of that. And so there are a number of really interesting administrative hurdles that folks point out, like the challenge of going through the Paperwork Reduction Act to actually do data collection in a more sort of structured way that really impede forms of machine learning within agencies. The other thing I'll just note here on the data front is one of the really interesting moves made by some agencies is, and this is connected to sort of 3G on the agenda of building internal capacity, is that a number of agencies have tried to basically bring in external talent by opening up their data systems. So you can actually potentially take a data set, create a kind of synthetic version of it. The CDC has done this really nicely through a kind of some open competitions to basically make certain data sets available so that you can empower the machine learning community, which loves to have these kinds of competitions to actually start to solve these important problems. So I do think that's a really interesting strategic move when it may be hard to build the kind of highly skilled internal team to solve these kinds of problems.
And I'd like to just add one point too, just because I think, Carrie, you were talking mostly about the issues with respect to data privacy and security being sort of standard. I guess I was really struck looking at least at particular agencies like FDA, where we have a case example in our report, but NHTSA, which didn't make it into the report, but we, in our study with students, looked at many of these agencies, although they have some have pre-existing sources of data, et cetera. The use of machine learning AI has really gotten them structurally to think much more about one thing Dan was talking about, like what is fit for purpose data as opposed to just pre-existing data. And then the second would be shifts to really new forms. So just to give a quick example with the FDA, it's a shift to, instead of having all of this data in the pre-market approval process, looking at the use of ongoing real world evidence data, et cetera, right? Just given the learning nature of machine learning and AI. And to me, that seems like actually a pretty significant and enormous and, a significant change or shift from how we might have been thinking of these issues before.
Thank you. Would anybody else like to be heard on transparency? Just raise your hand on the screen if you would. Deirdre, am I right there?
Yeah, and I wanted to kind of tie together the data, the transparency, and the delegation and accountability. You know, I think when we're talking about transparency, that it's important to ask transparency to whom and for what. And I think that, you know, when we're thinking about some of the delegation issues, transparency becomes so important when we're thinking about what issues need to be ventilated as policy choices that are in these systems. I know there's a wood chopper outside my house. I really apologize. You know, but when we think about the assumptions behind the choice of methodology, models, when we think about data, issues about how the data is cleaned and where it's sourced from become incredibly important to thinking about all of the bias issues that we were talking about earlier. And I think that there are two areas, you know, there's obviously a lot of work that's being done in the private sector about ways to make information about models and data more visible, both to the people who may be being judged by them, but also the people who are relying upon them so they know whether or not they're fit for purpose. But the other place that I think it's useful to look at is the literature and the reproducible research community, because I think we can think about, you know, these models as that, you know, there's a level of research design that's going in here, right? How do we take a complicated construct and turn it into something that a system can predict? And so like those issues of construct validity, et cetera, become really important. And those relate to both the data choices that are available and really relate to the transparency issues.
Very good. Does anybody else want to be heard on data collection, et cetera, or are we ready to move on to sourcing? Toby Dorsey, one more point.
Yeah, what was just said, transparency to whom, to me, that's everything here. It's are we transparent to the public? Are we transparent to academia? Are we transparent to Congress? Who's going to testify at the oversight hearing? And what is that person going to look like? Are we transparent to our own internal IG? So I definitely think that some statement that we make should in some way point out these issues.
Interesting. I think this is the first mention of internal executive branch disciplinary and oversight processes from Congress. Thank you. So I think, seeing nothing more, I think we're ready to move on to sourcing at this point. And by now the consultants should know that I'm going to try to cut the corner and see if they would like to discuss something that struck them as interesting for ACUS to keep in mind when writing up the statement when we get to the sourcing issue. Kerry?
Well, by sourcing, I take it we mean contracting and the issues that we've actually raised. Some number of us have raised this already. Is that what you mean, John, by sourcing?
That was my interpretation.
Great.
But if there's a different interpretation, could you let us know?
No, no. I thought maybe there could be something else that I don't know what that meant. So sourcing, yeah, I think, listen, that's a lot of the expertise that government has already, as we know from the former chair of the administrative conference, Paul Verkeil's work, you know, is outsourced, and government contractors are performing so much work. And that's clearly something that arises in this particular context. And I just want to echo what I think has been said by a few people already, that those contracts need to be negotiated and written with in mind the subsequent need for availability of information about how the algorithm is working, what the data are that it's using. These can be all worked out, I think, ahead of time, even while respecting some core trade secrets and innovations that are rightly, you know, something that a contractor could claim to have a right to confidentiality about. But nevertheless, to plan those things out in advance. And so in some sense, the sourcing questions are really related to everything else. So thinking ahead to what the potential legal concerns might be about bias, about transparency, And will we make sure that the government has adequate information? In my paper, Transparency and Algorithmic Governance, in the Administrative Law Review, I talk much more extensively about what I think those government contracts should entail. I don't think it's, again, anything that's truly distinctive. It's just contracting, but do it thoughtfully with in mind the later uses for demonstrating, as Don Elliott, I think, rightly said before, that there's going to need to be some ability to show the public or show those who are affected by decisions that these algorithms have been validated and that they are designed for the purpose that they are being used, and they're effective at that.
Thanks, Kerry. We'll turn to Don Elliott next, and then Toby Dorsey again.
Yeah, I just wanted to offer a point about this issue of internal delegation or delegation to private parties. I think that's a particularly important issue for some of the reasons that Kerry talked about. And just from an EPA perspective, because I think EPA has probably dealt with delegating decision-making to contractors as much as any agency. I think their general position, which I believe to have generally been withheld, to be upheld, both under the FAR, but also as under general principles of administrative law about not delegating to private parties like Carter versus Carter Cole, and there's a whole line of those kinds of cases. I think what's distinctive about AI is that for some of the reasons that Kerry has indicated and Daniel has indicated about the inscrutability of some of what's going on in an AI, there may be questions as to whether or not the traditional way of solving the delegation doctrine is sufficient here. How can you have somebody in government review a recommendation from an outside party and adopt it or not adopt it if the person doing the review can't really understand what's going on in the system? So I think those issues should at least be identified. I'm not sure that we can solve them in this initial report, but I think we should perhaps identify them as areas where there may potentially need to be some future work as the law matures.
Thank you. We have all lined up now with Toby Dorsey, David Engstrom, and Daniel Ho. So Toby, if you'd like to go forward.
I made my point in the chat, so I yield back the balance of my time.
Thank you. David?
Sure. So in our report, we have a whole section on building internal capacity and sourcing, which I think are actually quite related. So I think this comment will end up spanning those two topics. The way we set it up in the report is I think the way anyone would, which is agencies are facing that classic make or buy decision, and there are advantages to each. The buy decision probably brings a higher sophistication tool. I think that makes sense. I think there's an increasingly large contractor space that works on this stuff that is feeding governments at all levels within the United States. And I think if you source something from outside contractors, you probably get a higher sophistication tool, all else equal. On the other hand, making the tool and producing it internally brings advantages too. And the thought that we put out in our report, it's not. I think there's still lots more study to be done on this, but we certainly have plenty of very colorful and illustrative examples. But the idea is that when the agency makes the tool themselves or itself, it probably leads to a tool that's better tailored to the governance task at hand, and that's really important. I think governance tasks, as compared to a lot of private sector tasks where machine learning is being used, are quite subtle and quite complicated. And so if you actually have internal agency folks developing the tool, you probably end up with a tool that's better tailored to those very subtle tasks. You probably end up with a tool that's more policy compliant, because of course the tool has to comply with what is often quite complicated regulatory and statutory backdrop. And I think I would trust agency insiders who have been working within that regulatory framework for a long time to develop a tool that's more policy compliant. And here I think is where some of Deirdre's work is really important. I think that internally made tools are more likely to be designed in ways, well, with accountability in mind. And I think that's just a really powerful and important point. Now, in our report, we offered some examples of this, and I think I already put Carrie on the spot with the sub-delegation idea, but let me put Dan on the spot, who's in the queue anyway, which is I think there's a very interesting innovation story at the Social Security Administration, and that's the part of the report, or one of the many parts of the report that Dan headed up. And so I guess I would invite Dan to talk about that, and he may have been preparing to talk about it anyway. So maybe I'll just hand it off to him to I guess convey what he saw as he worked with SSA as we were completing our report.
Thank you. The new batting order is Daniel, Catherine Sharkey, and then Deirdre.
Yeah, I was actually planning on speaking to something else, but at the SSA, one of the really, just to speak to that point briefly, the kind of great innovation story is the way that sort of Gerald Ray, when he became head of the Appeals Council, really saw the way forward and built both the data infrastructure and personnel. I think Kurt Glaze may even be on this call to really prototype and figure out what could be addressed through forms of data science and machine learning. So we have a longer kind of case study of that. ACUS is kind of obviously well aware of that work, but happy to talk about that in more depth if people are interested. The comments I did want to make just on the sourcing point are fundamentally, I think a lot of agencies face this huge information asymmetry that people have talked about in various forms. And so one of the questions for me that I think is really important is how one starts to reduce that information asymmetry. If the contractors know way more about the technology, how is an agency ever supposed to know whom to award the contract to? So I think that does require sort of internal capacity, but there's also some really interesting initiatives that we observed. So the Customs and Border Protection Agency actually did run pilots. So they sequenced the form of contracting to first have a series of pilots where they had multiple contractors in, and then evaluated how those performed in the particular settings. NIST has been very important for doing benchmarking and performance assessment of, say, something like facial recognition technology. And ideally, you'd have just much more of that kind of A/B testing to really evaluate in-domain performance as systems like this are built out. The last point that I just want to emphasize that I think is really important to keep in mind that we've already mentioned, I think Alex Givens made it, is the trade secrecy point. There was one agency that had contracted out an AI-based solution and discovered a whole series of errors and could not get the contractor to actually answer where the errors were coming from because of the sort of trade secrecy proprietary protection that was invoked. And I think that will impede all of the lines of inquiry that we've talked about in procedural due process to try to actually improve the accuracy of these kinds of decision tools.
Thank you. Catherine, Deirdre, and then I'd like to go on to building internal capacity. We've only got about 15 minutes left. So let's finish this topic and then try to fit in a discussion at least of internal capacity.
Right, sorry, so my comment was on internal capacity, so I'll hold on.
All right, I'll open with you on that issue.
Okay.
Deirdre?
Sure. The other thing I just wanted to say on data collection, one of the things that I think is really an important insight from the private sector is issues of model transferability, right? The ability to train a model one place and use it someplace else. And one of the things that's come up in the context, for example, of the risk recidivism tools is this question of, are they locally trained or are they trained on a national data set? And I think that the question about people don't even, like when somebody says, oh, it needs to be trained locally, I look at the machine learning experts and I'm like, okay, so what properties make something local? What, like, is it Wisconsin and Minnesota? Is it like, and there's no like formalization right now that I have seen anybody in machine learning offer to me about how to know where it is inappropriate to train to use a model that's been trained on one data set on another data set. And I think that it's incredibly important to understand both kind of the data collected, the data that's been trained on, and to understand what differences that might arise. And this came up it comes up in both Carrie's report and also in Dan's report. But this, I think Carrie put a really nice point on it, like when the external environment is changing a lot, we have some real questions about the ongoing validity of the model that's been developed based on the training data we had. And this is not a transfer learning problem, you know, from hospital A to hospital B, but it's more of a transfer learning in the future, right? And understanding what things make the data we trained on no longer good data, I think is a really important problem because like how often do you need to update a model? What should trigger the update of a model? And these are all serious data collection issues. So I just wanted to raise that.
Okay, thank you. Catherine, if you'd forgive me, David Engstrom has one more comment on sourcing, so let's take it, try to be quick, and then we'll come to sourcing. I'm sorry, to building internal capacity.
Okay, I will be quick. It piggybacks on what Deirdre just said, which is I think that questions around sourcing and internal capacity have a federalism cast. I think that the development and the uptake of these tools at the state and local level is far more likely to come through contracting. And the reason why that might matter to this committee is that a lot of that is happening in areas like program integrity, where it's a cooperative federalism setup. And so I think if you look across the state and the local level, you're seeing pretty rapid adoption of algorithmic tools for program integrity around food stamps, unemployment insurance, Medicaid. And so these are areas where federal agencies actually have oversight duties. And so I think that's worth thinking about. It may even be, this may be a peripheral point, but it may be a place where some further study could be required. This could result in some sort of a further project where we would try to help federal agencies understand how they can help state and local agencies that are developing these tools, often through contractors, come up with better ways to ensure that there's proper accountability.
All right, thank you. Building internal capacity, and Catherine, please kick us off.
Yeah, just a brief, our time, I see we have 10 minutes collectively, so I'll be very brief, except maybe I'll just frame it this way, that before we launched our study and report, there was lots of stuff in the literature, right, about how the public sector, the government will be at a dramatic disadvantage, all the expertise, everything is in the private sector, et cetera. And I think while aspects of that are true, one of the most surprising things is our report serves up kind of examples of pretty incredible sophistication within individual agencies. So one aspect, not the only, but one aspect, while our report, and I take it this committee, is focusing primarily on agencies' internal uses of AI, many of these agencies, of course, regulate AI in the outside world. And some of those agencies have a real incentive to develop internal expertise. So to give one example, the FDA we uncovered had like an internal incubator, right? They were publishing peer-reviewed pieces on various AI technologies. And we talk in the report about how one, but not the only purpose of this, is to kind of de-risk for the regulated industries, some of these technologies, et cetera. So I do think it's important that we ground whatever we're saying. To go back to Jillian's point, it's going to be incredibly difficult because these examples are agency specific, et cetera. But I think we should start at least with kind of an empirical understanding of some of the great developments in terms of internal capacity already happening in various agencies.
Thanks very much. Does anyone else want to be heard on internal capacity? And Catherine, I appreciate your sticking to a big ticket item. If anyone else has a big ticket item to share on this point, I'd appreciate hearing from you. Yes, sir. Dan?
Yeah, I guess one thing that I think, just to build on Kathy's point, machine learning and AI advance incredibly rapidly. And so one of the things that's very hard is to build internal capacity that can actually keep pace with the really furious development that's happening in machine learning. And so the other, Kathy mentioned the FDA example. FDA had a very interesting vehicle called the CERSI Centers, the Centers for Evaluation for Effective Regulatory Science, that are these academic collaborations with universities to really foster more direct collaborations. And so I think the other thing I would highlight here is that some of the most creative uses came out of the use of fellowships, off the Intergovernmental Personnel Act, off of cooperative research and development agreements, these kinds of things that are really vehicles by which you can infuse expertise really rapidly to build up the internal capacity through these kinds of collaborations.
All right, fine. Carrie, I see your light is on. One more comment there, and then I'll close the window and try to see if we can get very, very quickly to risk of gaming and adversarial learning and see if people have some really big ticket items that they've been dying to tell us. Go ahead, please.
Well, one possible idea for a recommendation in the building capacity area, maybe Kathy, Dan, or David encountered this, and maybe it's already in place, but I know in other areas the government has for digital services built cross-governmental working groups and opportunities for collaboration and diffusion of innovation and knowledge. And that might be something to consider if the government already doesn't have that in place at the federal level.
Thank you. And then 5 minutes we have on the risk of gaming and adversarial learning. Who's got a point they're dying to make? Nothing's come up yet, so I'll follow my well-trod track at this point and ask the consultants what issues struck them as most significant in this area.
I guess I would just remake a point I made earlier in this meeting, which is that the transparency that we demand from a particular tool is going to vary tremendously by context. And so I think here's a place where the concerns about gaming might lead us to a very different place in terms of how much of a algorithmic tool or the inputs or the outputs, it doesn't matter, we want to make public. I think again we should think hard about enforcement versus adjudication. That's the example I gave previously, and I think there I think it's going to be very context. Sorry, my computer. I'm sorry, folks. My computer is telling me that I have to. I'm sorry. I'm gonna mute other than and just leave off with that point about contextuality. Sorry.
I'm going to let Don Elliott go next, and then Carrie, you'll have the last word.
Nina, I think, has a comment.
Oh, sorry.
I will be very, very brief. I would just urge that people should be reflective that there's a fine distinction between gaming that some people consider undesirable and regulating by incentives. And I guess the second and really related point is this is not unique to artificial intelligence. We have a problem in, say, the environmental area. If we pick an averaging time for a national ambient air quality standard, but actually the harm takes place over a different time period, then there's a mismatch between the incentives. And we have had instances like that where we started out measuring total suspended particulate by weighing it. And that had a tendency, of course, to bias the collection and the design of equipment based on being ability to collect the heavier particles. And as science progressed, we discovered it was really the smaller particles that were causing the harm. So that's an example of creating an incentive structure for measuring compliance under the present system, which has similar problems of you want to get the metrics right so that when people respond to the incentives, you don't regard it as inappropriate gaming. You regard it as having people respond. Same thing with a lot of the automobile cases like VW or Daimler that we saw, where companies were creating systems that could comply with the specified provisions in the regulations, but that was not really representative of on-the-road performance, allegedly. So I just want to note that's not a unique problem.
So, Nina, why don't you go next, and as a way of expressing my appreciation for his summary In the article, I'll let Carrie Stillbett at the last position. Nina, please go ahead.
Well, I think I'll follow up with what Don said. And also, David, I think it's not just the context of enforcement, but actually the agency itself. And since I have worked within an agency that defines itself as an enforcement agency, many of my battles have been in other contexts under FOIA, et cetera. How much information it gives out to taxpayers so that they know what they need to do in order to comply. And when the consequences of a government's position or determination are so great, as they can be with the IRS, I think you have to weigh on, even in the enforcement context, providing information, how you're arriving at that decision. And how you do that with an algorithm is going to be, to me, very, very difficult. It's already very difficult and facing lots of opposition internally, since the agency's culture is to see people as, gaming the system.
Thank you. A word for the wise there. Carrie, did take us to the finish line.
Well, thank you for all you've done here today, John. I'll be very brief. I want to build on Don's point and say that part of the issue, I think, is certainly gaming, but part of it also is that regulators typically and government officials typically have more than one objective in mind. You want to, solve a problem, but you don't want to create side effects. And one of the things that you can create when you regulate by objective and performance-based regulation, the kind of emissions tests that gave rise to the VW emissions scandal that Don mentioned, for example, those are regulating by setting objectives. And what can sometimes happen is that people then go ahead and try to meet that objective, but do so in ways that create other problems. I've written about this in a paper called The Law of the Test and another paper, The Limits of Performance-Based Regulation, but it applies in the context of any use, I think, any use, whether it's for regulatory purposes or otherwise by the government. Algorithms operate by having an objective function that they're designed to optimize for. And if you don't, when you're creating those algorithms, think through very carefully what is the objective we care about, what are the multiple facets of the objectives, what are some of the trade-offs that might be from one objective and another. You can really design a system that gets you what you want, but also brings with it other things that you don't want. Ellen Goodman has a wonderful piece in the Regulatory Review about the city of Boston using a machine learning tool to optimize on its school bus system. And they wanted to minimize the amount of fuel that's used by their buses. They did that very well, but they upset the rest of the community because the school bus schedules were just so crazy for parents to plan their lives around. So there's always, I think, in government, we care really about multiple things. And I think that would be my closing thought, would be when proceeding with algorithms to replace government functions, we not only have to consider all the issues that we've talked about, but also from the very beginning, just be very clear and comprehensive about what are all the things we care about and that might be affected by this tool.
Thanks, Carrie. This has really been a very impressive performance by an all-star team today. I've learned an enormous amount. It's really overwhelming for an outsider to hear the amount of intellectual firepower that's been devoted to the topic. So I'll thank you personally, and then I'll pass this back to the folks at ACUS if they want to have some kind of quick closing comment here. And seeing that.
John, the only thing I would like to reiterate is a point that Carrie had made in, I think, attributing a comment to me that I'm not sure I made at the outset, but should have, which is that one important function of this statement could very well be to identify subjects that ACUS should either take up in further studies or address by recommendation based on the existing studies. So with that, let me just turn it over to Mark to see if there are any logistical or administrative matters that the committee should be aware of before we sign off here today.
I think the one thing I can think of is how we might handle a vote in terms of whether there's agreement that a statement is warranted on one or more of these topics. Is that something that we want to handle online? Is that something that we'd like to get done here and now? I leave that to John, you, Matt, and then we perhaps.
Well, I don't think we can handle it now because the committee meeting is over, or that we've hit the allotted time mark. But it's certainly something that we'll need to address before the next meeting.
All right. Well, in that case, you guys can look out for that. And I don't think, John, unless there's anything else, you can wrap up the meeting.
Thank you. Nothing on my end. So I'll declare that having consumed our allotted period of time, the committee is now adjourned.
Thank you all very much.
Thank you, John.